The Trump administration can withhold millions of dollars from law enforcement agencies in states and cities that do not cooperate with U.S. immigration authorities, a federal appeals court ruled on Wednesday.
The decision, by the United States Court of Appeals for the Second Circuit in Manhattan, was the first by an appellate court to side with the administration's argument that it can impose conditions on the release of the money, which comes in the form of grants.
3 other appeals courts have previously affirmed lower court rulings that it was unlawful for the White House to tie the grant money to state and local governments' cooperation with the federal authorities.
Administration officials hailed the ruling.
Today's decision rightfully recognizes the lawful authority of the Attorney General to ensure that Department of Justice grant recipients are not at the same time thwarting federal law enforcement priorities, Alexei Woltornost, a Justice Department spokesman, said.
Officials with the jurisdictions that filed the lawsuit that led to the decision vowed to continue battling the administration.
President Trump's latest retaliation against his hometown takes away security funding from the #1 terrorist target in America, Mayor Bill de Blasio of New York City said in a statement, all because we refuse to play by his arbitrary rules.
We'll see President Trump back in court, he added. And we will win.
Gurbir S. Grewal, the Attorney General of New Jersey, said he was disappointed by the ruling and he, too, indicated that the fight was not over.
It's unfortunate that the federal government has decided to weaponize the federal grant funding process in order to carry out the president's anti-immigrant agenda, Mr. Grewal said, but I'm confident that we will ultimately prevail in the courts.
The decision comes amid an escalating crackdown by the administration on so-called sanctuary policies, which limit the extent to which state and local law enforcement agencies can help federal immigration authorities.
New York City, Chicago, Philadelphia, California and other places that have such policies have seen increased activity this year by Immigration and Customs Enforcement, or ICE, which has diverted agents from the southern border to assist with arrests in some areas.
The agency has also issued subpoenas to law enforcement authorities in sanctuary jurisdictions seeking information on immigrants in their custody, and its acting director, Matthew T. Albence, has denounced the policies in sharply worded statements as threatening public safety.
The Second Circuit ruling, by a unanimous 3-judge panel and written by Judge Rena Raggi, reversed a lower court judge's decision, and found that the federal government had the discretion to impose conditions when distributing grant money.
The appellate opinion, which applies only to the jurisdictions that filed the suit, noted that the Supreme Court had repeatedly observed that the federal government has power over states where immigration policy is concerned.
Judge Raggi, who wrote in her opinion that the case involved several of the most divisive issues confronting our country, was appointed to the federal bench by President Ronald Reagan and elevated to the appeals court by President George W. Bush. Also on the panel were Judge Ralph K. Winter Jr., who was appointed to the Second Circuit by Mr. Reagan, and Judge Jose A. Cabranes, who was appointed by President Bill Clinton.
The case was brought by New York and several other states after the Justice Department announced that it would withhold grant money from localities that denied federal immigration authorities access to jails, among other conditions.
Judge Edgardo Ramos of Federal District Court in Manhattan ruled in favor of the plaintiffs in 2018, saying that the Trump administration did not have the lawful authority to impose such conditions on funding.
Judge Ramos blocked the administration from enforcing its conditions on New York City, New York State, New Jersey and 5 other states that joined the lawsuit, Connecticut, Massachusetts, Rhode Island, Virginia and Washington. It
was unclear on Wednesday which of 2 options the states involved in the New York case might pursue, requesting review from the full Second Circuit, or asking the Supreme Court, which typically resolves conflicting rulings among federal appeals courts, to take up the case.
The grants in question, the Edward Byrne Memorial Justice Assistance Grants, are the biggest source of federal law enforcement funding to state and local jurisdictions. New York City has received about $4 million a year in such funding. The money has, among other things, paid the salaries of emergency responders and covered the cost of drug prosecutions. The dispute has its origins in an executive order issued by Mr. Trump early in his term that directed the Attorney General and the Department of Homeland Security to make sanctuary jurisdictions ineligible for federal grants. The order was successfully challenged. In July 2017, Jeff Sessions, the Attorney General at the time, zeroed in on the Byrne grants, imposing a set of conditions that effectively rendered sanctuary jurisdictions ineligible for the money.
The conditions included requiring grant recipients to allow federal agents to interview immigrants in their custody and to provide the federal authorities with notice when immigrants were scheduled to be released.
The three appeals courts that previously ruled against the administration, in Chicago, Philadelphia and San Francisco, all found that such restrictions were improper.
This decision is a total break on what has been a unanimous decision from courts and judges across the country that this is illegal, said Cody Wofsy, a staff lawyer with the American Civil Liberties Union Immigrants' Rights Project, which filed an amicus curiae, or friend of the court, brief in the case.
Mr. Wofsy said the limits on grant money were part of the administration's larger campaign to coerce and force states and local governments to become part of the federal deportation system. Under the U.S. Constitution, he said, states have the privilege to refuse.
The crackdown on states with policies and laws that shield undocumented immigrants has been felt acutely in New York in recent months. After a law went into effect allowing such immigrants to get driver's licenses, and barring federal agencies from gaining access to a motor vehicles database, the administration barred New Yorkers from enrolling in trusted traveler programs like Global Entry and halted the export of cars with New York titles.
In a statement, Stephen Choi, the executive director of the New York Immigration Coalition, said, "Today's ruling essentially sanctions the federal administration's extortion of cities who have enacted policies to ensure local control of law enforcement dollars and protect immigrant communities."
The Byrne Grant Program, which dispenses more than $250 million a year, was created in 2006 and named for a New York police officer who was fatally shot while guarding the home of a cooperating witness.
Officer Eddie Byrne's legacy reminds us that maintaining strong relationships with immigrant communities keeps all New Yorkers safe. Bida Mustafi, the city's immigrant affairs commissioner, said,